Samalia Dr Tunku Intan Mainura, BINTI Tunku Mamar. So today, we are going to present about the application of the Doctrine of Judicial Precedent in Malaysia and also the circumstances when a court departs from the previous decision.
Before we go any further, our group members consist of HANIS NASUHA binti MOHAMAD TAIB, UMMI WAHIDA binti ABDUL SHUKRI, NURUL FATIN NAJWA binti JALALUDIN, and last but not least, NURUL KHAIRUNNISA binti YUSRI. Hello Ummi, are you busy right now?
Well, hello there, Hanis. No, I'm not busy, just scrolling through the news.
Oh my god, Ummi, I have a test today, and guess what? I totally forgot to study for it. The topic for the test is the application of the Doctrine of Judicial Precedent in Malaysia. It also says to consider the circumstances when a court may depart from a previous decision. Please tell me you'll help me out here.
You have come to the right person. Yes, I can help you. First and foremost, what do you remember about judicial precedents?
Well, I'm aware that the Doctrine of Judicial Precedent is a source of law in which past decisions create law for judges to use in future cases. When the court chooses to apply the ratio decidendi of these past decisions to a sufficiently similar present case, the judicial precedent now becomes a binding judicial precedent. On the other hand, an obiter dicta, which is a passing remark made by a judge, does not have the same binding effect as a ratio decidendi. The obiter dicta is mainly only persuasive in nature, but if it's highly persuasive, it may become a ratio decidendi in subsequent cases. In Malaysia, as of now, this doctrine is applied through two mechanisms. The first is the vertical operation, and the second is the horizontal operation. Isn't that right, Ummi?
Yes, that's right, Hanis. There are two operations for judicial precedents. The first one is the vertical operation. Basically, vertical operation works when a court is bound by prior decision of higher court. For example, magistrate court is obligated to follow decision of session court which is higher in the hierarchy than the magistrate court. This doctrine can be seen in the case of Jason Chang Huan Seng and Onri Cognizant and PP 2014. The fact was the Court of Appeal determined that it is crucial to remember that the doctrine of stare decisis requires Court of Appeal to adopt a federal court decision and its own previous decision as a matter of general principle of high importance. In the case of Hari Solid State M. Sdn Bhd and Onri Cognizant and Bruno Gentil significant other para state that Council for Appeal argue majority decision made in the case of Ramachandra and the Industrial Court of Malaysia and Anna is wrong and should not be followed. The Court of Appeal reject the Council position holding that court must observe and apply the law as expressed by the majority in Ramachandra. Despite its flaw, it must be followed. Second, in the case of Cooperative Central Bank Limited Liability and Foreign Development Sdn Bhd, the challenge was whether an intermediate court of appeal could ignore a final court of appeal judgment on the basis of per inquirium. The court of appeal cannot reject the House of Lords decision even if it is unfavorable according to the court. However, if the Court of Appeal issue two conflicting decisions, the court may choose one most appropriate in the circumstance based on the case of Dalit Bangwan Singh and Public Prosecutor. I guess that's all for vertical operation. Now, I'll pass the phone to Fatin Najwa to expound on horizontal operation.
Hello Hanis, it's Fatin Najwa here. So for the horizontal operations, it involves the three main court, which is the Federal Court, Court of Appeal and the High Court. So we will look at the Federal Court first. In the civil cases, the Federal Court does not consider the Supreme Court decision is binding. We can see in the case of Malaysian National Insurance and Ling Tiok. Other than that, in the case of Tan Chee bin Ibrahim and Safety Life and General Insurance Sdn Bhd, the Federal Court reviewed this case and stated that it was wrongly decided by the Supreme Court and the decision should not be followed by the case of Food Corporation of India and Aklizo Shipping Corporation. So, what's about the criminal cases? In the criminal cases, the federal court is bound by the Supreme Court's decision. We can see in the case of Aru Pragasan anak lelaki Sandaraju against public prosecutor. The judge in this case was support the view that the federal court should bound by the Supreme Court decisions in the criminal matter. However, the issue was arise whether the federal court is bound by its own precedent. The answer is no, because the federal court can depart from the previous decision. This can be seen in the case of Koperasi Rakyat and Harta Empat. Next, it is about the horizontal operation in the Court of Appeal and the High Court. For the Court of Appeal, it shall be bound by its own decision. This can be seen in the case of Kumpulan Perasan Selangor Berhad and Zaid bin Haji Muhammad Noor, and in the case of Kesultanan Pahang and Satak Realty Sendirian Berhad, and also in the case of Syarikat Kenderaan Melayu Kelantan Berhad and Transport Workers Union. The judges in these three cases was stated that the Court of Appeal is bound by its own decision. In the High Court, the general assumption that one High Court judge is not bound by a decision made by another High Court judge, either from the original or appellate jurisdiction. This can be seen in the case of Ang Hoi Chew against public prosecutor and in the case of Wong Hen Fat against public prosecutor. The judges in these two cases stated that High Court judge does not bind by another High Court judge decision.
Oh yes, these two operations are reflected in the recent local case of Kejuruteraan Bintai Kindeko Sendirian Berhad and Fong Sun Leong. In this case, the High Court followed the decision of the Court of Appeal as per the vertical operation. On appeal, the Court of Appeal upheld its own precedent as per the horizontal operation. Having said that out loud, I now wonder, are there any exceptions to this doctrine?
Hi HANIS, it's KHAIRUNNISA here. I thought I'd hop on the call to help explain about the exception to judicial precedent. HANIS, do you know that there are situations in which judges do not have to follow early decision of the court? An exception was set out in the landmark case, which is the case of Young and Bristol Airplane Company Limited. In this case, the Court of Appeal is bound to follow its own decision except under three situations. First situation, where there is a conflict between two previous decisions of the Court of Appeal. This rule was also explained by the Federal Court in the case of Dalit Bangkuang Sin and Public Prosecutor. In this case, the Federal Court qualified an earlier High Court decision in the case of Datuk Tang Leng Tek and Sarjana Sendirian Berhad and others. It is concluded that when two conflicting decisions of a higher court exist and the latter decision does not profess to overrule the earlier, a lower court may select which to follow based on its own judgment of which is more persuasive. Move to the second situation where a previous decision of the Court of Appeal has been overruled either expressly or impliedly by the Federal Court. This means that the Court of Appeal must also refuse to follow its own decision if it cannot stand with the decision of the Federal Court, even if the decision has not been expressly overruled by the Federal Court. Third situation, which is the last exception, is where the previous decision was given per inquirium. Let me give you one example, HANIS. When a court ignores the law and proceeds with a judgment, the decision falls under the per inquirium spectrum and does not necessarily have to be followed. Not only in civil cases, the Court of Appeal in criminal cases also can depart from its previous decision if it finds the matter of the previous decision has abused or misinterpreted the law. This rule was stated in the case of Regina against Gold. In this case, Lord Diplock stated that in criminal cases, the court will not use the notion of judicial precedent binding with equal firmness. However, if the court believes that a previous decision abused the law, the court has the power to deviate from the view of the legal decision.
Ah, I understand now. Basically, the courts in Malaysia are subject to the vertical and horizontal operations of judicial precedent. There are, of course, exceptions to preclude the binding of past decisions to a present case.
Yes, Hanis, you've got that right.
Thank you for enlightening me on this topic. Now, wish me luck on the test.